The Multistate Bar Examination, MBE, is a critical component of the bar exam in the United States, testing a candidate's knowledge and application of fundamental legal principles across multiple areas of law. Statistically, the hardest area of law on the MBE is evidence. This difficulty can be attributed to several factors, including the complexity of the rules, the depth of understanding required, and the nuanced application of legal principles. In this article, we will explore why evidence poses such a challenge to test takers and how it compares to other areas of law on the MBE. Evidence law is intricate due to its detailed rules and the requirement for precise application. The federal rules of evidence, which govern this area, are comprehensive and contain numerous exceptions and conditions. Key areas that contribute to the complexity include: 1. Relevance and admissibility. Understanding what constitutes relevant evidence and whether it is admissible in court involves multiple layers of analysis. Candidates must be familiar with both the general principles and specific rules, such as Rule 403, excluding relevant evidence for prejudice, confusion, or waste of time. 2. Hearsay. The hearsay rule is notoriously difficult due to its numerous exceptions and exemptions. Candidates must not only know the definition of hearsay, but also be able to identify and apply the correct exception in various contexts. 3. Character. Evidence. Rules regarding character evidence and its admissibility are complex. Candidates must understand the distinctions between when character evidence is allowed and when it is prohibited, as well as the different methods of proving character. 4. Privileges. Legal privileges, such as attorney-client privilege and spousal privilege, involve specific conditions and exceptions that must be precisely understood and applied. 5. Witness examination. The rules governing the examination of witnesses, including impeachment and rehabilitation, require a nuanced understanding of procedural and substantive principles. Studies and surveys conducted among bar exam candidates and preparation course providers consistently show that evidence is perceived as the most challenging subject. Data from the National Conference of Bar Examiners, NCBE, and various bar review courses indicate that students score lower on evidence questions compared to other subjects. This statistical trend can be attributed to the reasons mentioned above, particularly the complexity and depth of the subject matter. While other areas of law on the MBE also present challenges, they tend to be more straightforward in terms of rules and application. For instance, civil procedure. Although civil procedure involves complex rules, the questions often focus on procedural steps and timelines, which are easier to memorize and apply. Constitutional law. This subject involves broad principles and landmark cases, making it more accessible to candidates who can grasp overarching themes. Contracts and tort. These subjects rely on well-defined doctrines and principles, which, although intricate, are often more intuitive than the technical rules of evidence. Criminal law and procedure. While complex, the fact patterns and legal principles are usually more concrete and less abstract than those in evidence. Real property. Despite its difficulty, the subject often involves tangible concepts and established doctrines that can be systematically studied.